All right, we will go ahead and get started. So good afternoon. Welcome to Business of Design, Design Center at the Mart's monthly lecture series. My name is Beth Hicks, Managing Director of Marketing, and I'll be your host today. So today is my pleasure to welcome McKenna Prohov to present Contracts 2.0. McKenna is a principal attorney and founder of LawX Design, providing legal and business services to design and creative professionals. Today, McKenna will review how to protect your time and maximize fees by learning what goes into an effective client contract. McKenna will expand upon her popular 2019 lecture and talk about the importance of contracts, agreements, and proposals specific to the design industry. We are very pleased to have her back, so please join me in welcoming McKenna.
Hi, thank you so much, Beth, for that introduction, and hi, everyone. Thank you very much for being here. While I have been a part of many Zoom calls over the past few months, this is my first time as presenter, as hosting. So it's a very different format for me. I can't see you. I look forward to when we can do this in person. I think it is absolutely the optimal way to learn about these things. And I really view this, as your time, your hour, and I want to be here as much as I can for you and be a very good resource, address some questions. And this is a little bit different. It doesn't quite allow us to have the same kind of back and forth that we might in person, but I'm very grateful for this opportunity. I'm grateful that we all have the ability to come together in this way today to facilitate, some learning. And my goal today is that you do learn something, a thing or two about contracts, and mostly just that, maybe I can help ping your brain and kind of get you in this space, in this contract space, working with contracts, first of all, for your business. Some people are just starting there and trying to decide, if they should use one or not, and I can talk about that. But what I love doing is helping businesses like yours level up, specifically designers. So hopefully, this just gives you, our time here together today will give you some things to think about and inspire you to kind of go back and to your business to some of this work to get you, as Beth mentioned, even more ready to practice and do what you love, to protect your time, maximize your fees. That's why you're doing this. So with that, I'm obligated by my profession to tell you, I just have to make a disclaimer that I'm not giving legal advice here today. This in no way constitutes official legal advice. I can't do that via this format without signing a client engagement agreement with you. So this is, a learning opportunity to give you kind of an overview, some backgrounds about different things, and some knowledge and pieces of the law, as they stand. It's not individual legal advice, and you recognize that we have not, that I have not retained you as a client. So with that disclaimer out of the way, I just want to take a couple minutes to tell you about my practice, Law by Design. I renamed my practice a couple years ago. Law by Design is a very important new name for me because it not only speaks to you, this group who primarily are my clients. Designers are the people I serve, but also speaks to providing really specific tailored legal services that are designed, to meet your needs. One of the things that I pride myself on is that I based my practice on a relational model, and don't think of myself so much as an attorney or a lawyer to you, but really, a counsel and an advisor. And while contracts and different things that I can help you do may have legal implications, I love really kind of serving. I'm another resource for your business. I enjoy serving in that capacity. I just happen to have knowledge and kind of be able to speak to the legal aspect of your business specifically. So I love what I do. I'm really looking forward to being a part of strengthening this community in 2021. I think that's what it's all about. So please do not hesitate to reach out to me if you think I can be of assistance to you. that is what I do. That's what I'm here to do and what I love. So with that, and without further ado, I'm going to share a few slides with you. I just talked a little bit about my practice. Here's some contact information. And I can go back to this slide. I should have had that up when I was telling you a little bit about my firm. But what I would like to do first, actually, I'm going to reverse engineer this a little bit and just kind of start out hot, maybe just have a little bit of fun with this. And I thought many of you took the opportunity to submit some questions ahead of time. And I had a chance to review them briefly before today. And I thought I might save those for the end, along with, you know, questions that you might submit here today. But I think what I'd like to do is go over some of them and just kind of, I'm not going to go into much detail on any one of them, but really just address what you guys have already submitted. I know, you know, people want to know, and hopefully this will just, you know, get you going and give you a quick, you know, kind of maybe brief answer to get you on some solid footing. And then hopefully, you know, over the course of this presentation, we'll be talking a little bit more about it in detail, and I can address, you know, some concerns in further detail. But I liked these so much, I'm going to do that first. So the first question, I love it. It's letter of agreements versus scope of project. Any way to combine these? Yes, I love scope in contracts. One of the things I do is work with my clients on building, you know, a form contract that they don't have to, you know, modify every time they get a new project or client. While terms do change, hopefully, you know, we get a really good kind of cohesive document where you can plug in things like scope. And what I like to do with my clients is, you know, really make sure that the legal provisions are intact, especially if, you know, maybe you're in the commercial space and you're getting contracts from another party. They're asking you to use their template, even though I recommend having a contract that's within, you know, a part of your business that you can pull up, that, you know, you just have on file. You might not always be able to use it, and I understand that, you know, and I review other, I review contracts coming from other parties as well. But scope is one thing that I ask my clients to look at always, because that's what you know scope best. You know what you've discussed with clients, you know what they're expecting. And it's the piece of the business that you really, you know better than I do. I would encourage you as much as possible to just work with one document. More on that later. So I, yes, recommend putting scope right within the definitive agreement that you have the client sign. I recommend calling that a contract as well, instead of a letter of agreement, and I'll get to that too a little bit later. One thing I want to mention about collection strategies, there were several questions about this, and I will say that when it comes to what I can speak to is when it comes to delinquent payments, which does happen. One thing that I do for my clients is send demand letters, and they've been very, very helpful. They're very conciliatory, I guess, is the word that I'm going to use right off the top of my head. I mean, they're firm. It's coming from my office. It's on my letterhead with my signature, which is just often what it takes to get someone who's non-responsive to you to just commit to paying, you know, what they agreed to pay. Otherwise, it is a breach of contract. So, you know, of course, I make sure to let the person know, but it's by no means something that is, you know, really meant to be angry and aggressive, and, you know, and threaten. That's not what a demand letter is. Demand sounds demanding. It's just, that's what those letters are called, though. If that's something that you need help with, you know, an attorney should be the one writing the letter and signing that letter. You know, it needs to be clear that the attorney is working on your behalf. And that's why the letter is being sent, is because, you know, that there's a delinquent payment that needs to be collected. So the next question I'm going to address right away is administrative tasks and how to charge. I can tell you that administration fee percentages, there is a range, as I'm sure you know, and I've seen different numbers, of course, depending on, who your client is on any given project, but just also who your base, tends to be typically. But I recommend putting, having a carve out under compensation and making the compensation section in a contract, very clear. And I would put it in an administrative fee clause right underneath that section, right? Compensation. And I think it's important to make clear that the reason why that's there is because there are out-of-pocket costs that might not be reflected in the base design fee that you and your client have agreed to. The next question is, let's see, some of these are just statements. I want to be sure that there are several questions on right format of these kinds of contracts, which gets me into the slide that I think you see now. This is the title of my last talk was called Which Came First, the RFP, DSP, or the Contract. RFP, Request for Proposal. DSP, I just mean the Design Services Proposal, or the documents that you might send out. You might call it something different, qualifications package, slightly different name. But what I mean is the documents that go out to your client in proposal format before they have officially agreed to retain you. They might pitch you and your business, your prior work, and probably give some brass tacks information about what this specific project is that you're going to be doing with a client. So time frame, the scope, and then of course the fee, what you would charge would typically be in this DSP. A lot of times when I start working with clients, they ask if they need a contract. They might be sending out these proposals and just having those proposals signed. Absolutely, I recommend a contract is better than a proposal. A proposal often just does not have enough legal protection in it because there are areas to address that are typically not included in the proposal, like say intellectual property. Just making sure that you state that as the designer, you do own your designs and you have copyright in them. The reason why I don't recommend putting these terms into the proposal is because it really doesn't make clear that you mean for your client to be, sort of bound by these terms when they sign the agreement and when they agree to work with you. When those terms are kind of embedded or mixed into a proposal, it just weakens the agreement. It simply weakens it because there's other information in there, like a pitch, which is really what a proposal is, that just, it tends to make it very, unclear or maybe murky as to, well, was this just something that, the client and the designer thought would be nice to agree to, or is this something, that the client agreed to and agrees, agrees to be held to those terms in a legal sense. Contracts do not have to be long or very wordy. I'm very aware of that. I know a lot of people might not want to send their clients a contract or don't think that they'll sign a contract, or certainly, don't want the contract to be a 20-page document with a bunch of legalese that no one understands. I'm very aware of that and very sensitive. And I think that, it's just really important to craft agreements that are really address, what your rights are, but that are simple and clean as well and manageable. And, I'm here to facilitate that, even to help your clients understand. And really, no one should be hesitant to sign anything like that, because while you're having fun, your business is fun. It's so much fun, but it's also, serious and important, and you deserve to have people recognize, right, that you are a business, that you're providing a service, and it helps facilitate a better working relationship. And your working relationship and the relationships you're trying to build with your clients are so important. And there should be a contract, reflecting basic terms, so that there's a greater understanding, because what this document does is provide clarity. It doesn't, it really doesn't do what a lot of people think contracts do, which is just limit you. It's not, supposed to be a limiting document, but rather something that, helps everyone get on the same page. It's kind of, I think of it as, kind of a respectful thing to do, because it says, that I trust you enough to take this seriously, to kind of, commit, right, to each other to do this the way that we agreed to do this. So, so I would, not put legal terms in your proposal. I would follow up a signed proposal, with a contract. It's important that these documents be linked using the appropriate legal language. There is linking language in the law that, where documents are incorporated to one another. So terms of the proposal do get incorporated, into the contract later. And I think it's important to, to kind of put in that proposal too, that there is an agreement to follow, so that your client understands that they're going to be, reviewing a contract, quickly. It can be short and simple. There's so many different ways to do a contract. They really can be, tailored to your business, to a specific project and to a specific client. So linking language is very important. All right. One of the things I did talk about last time is how important it is to separate your base scope of services and your additional services. And this is probably one of the ultimate top 5 biggest ways to protect your time and fees in the contract. That's why I think being so detailed in scope is really important, and why scope should be in a contract. I have seen a few different strategies work out very well as far as additional services. Sometimes they are spelled out in the contract. And if you find that you're in a situation where there's something your clients often want that is outside scope, and maybe you haven't been charging for, or you feel like, oh gosh, I just kind of gave up that service, like I wrapped it into my base scope, but technically now I'm making less. I might, spell that out in the contract. There's definitely additional services provisions within the contract. Some of my clients, though, have told me they don't want to use up that contract space, or sort of put in front, right, everything that's not included. Maybe they don't know their client as well, and they think that, there's going to be a discussion or kind of confrontation, and that people, will say, why isn't this included? I don't understand that. Don't think it's fair. I thought that it would be. What I mean by multiple effective strategies, though, and this is a business decision, and we can talk more about this, and I can work with you on right, a case-by-case basis. Sometimes having the additional services for the client to look at has actually increased base scope fee, because the client, it just pings their brain and they're like, well, this is something I want to talk about this. This is actually something I think that I would want you to do. So let's talk, kind of renegotiating this base fee, and you can, make that part of your base scope, right, on a case-by-case basis. So it can work that way too. It's just really important to separate that out, because otherwise I think, you run into scope creep, which is hard, and you don't want a client, to take advantage of you in that way. They might not mean to, but it's just, one really important aspect to a contract, and one really important way, like I said, to protect to protect your time and protect those fees, or, increase those fees, is by really separating exactly, you know, what's included in your base design fee and what's an additional service on top of that. And then you have to enforce it. Very, very important. Don't say that something's an additional service and then give it to your client for free. You just, you know, what's kind of nice about making sure that you do this in a contract is so that you can go to it. You know, you kind of just use it, like lean on it as a crutch and just kind of say, hey, yeah, this is, you know, this is right here. It's in writing, and it's what we agree to. And this is kind of what I mean too about why it's so important to have a contract, is because all kinds of things come up like this, you know, over the course of the project. Things change and things are always evolving, and it's even a little bit nebulous to pin down, and these things are all good and all fine, but you want to have sort of the tightest agreement to start you off that you can. So separating those base scope of services and additional services, very important. Whoops, let me go back there to the next slide. I wanted to just take a little bit of time to tell you guys about some trends that I'm seeing in my practice. Some of this isn't quite new, and you might be familiar with it yourself. And by new, you know, I don't mean last couple months. I mean, you know, last, you know, few years or something, but that's relatively new, right? In terms of how designers are being treated in a legal sense in their working relationships, in the contracts too, that they might sign. So I've seen, I think, that contractor treatment, kind of treating the designer not as the design professional and the interior designer on the project, but like a contractor, even in the residential space. I think that that's becoming much more common. I think that's because, you know, it's possible that a lot of people don't quite understand what a designer does. And certainly in the commercial space, I've seen tons and tons of contracts coming, you know, from owners who want to treat the designer like a contractor or like a sub. And one of the ways that comes through the most is through insurance. I'm seeing a lot of designers asked to kind of be carrying a lot more professional liability, you know, to up that number right in their policies. And I work actually for my designers in the commercial space for whom this has come up. I have talked with their insurance reps. You know, I work with other professionals too who might touch your business, like accountants, tax consultants, and things like that. It's really important sometimes to kind of go get that specific, you know, perspective and expertise, and just say, hey, I'm seeing this in a contract. My piece is the contract, but I want to ask you, you know, insurance rep, if these limits are just above and beyond what we should, you know, if we should up these limits, right? Things like that. Intellectual property assets. I haven't talked about what intellectual property is yet. I planned on doing it later, but maybe I should tell you guys now, just so, because I'm mentioning them now. So by intellectual property, I'm referring to, well, intellectual property refers to really, it's a large umbrella of works that are created, right, by people that are able to be legally protected. So for which legal protection exists at the state and federal level. So creative works, you know, range greatly. If it's an invention, the intellectual property is called, you know, a patent. That's the intellectual property right then is called a patent right. Obviously creative works include, you know, music, literature, paintings, design. So for our purposes here today, we're talking more about trademarks. That's an intellectual property right. So like logos and marks are protected, and also copyright. That's what your designs are. So any drawing, you know, that you do, that's copyright, and copyright is a kind of intellectual property asset, and so is trademark. Trademark is a type of intellectual property asset, and both of those are protectable. Designs are copyright, and that right flows to you naturally. So there's common law rights to it. That's why every time you design something, you don't have to, you know, file something with the state to get protection for it. It's just the law says that that flows to you automatically. You don't get the little C stamp on it, but that doesn't mean that it's not yours, and that you don't have a right to it because you created it. So the standard default language for protecting your copyright in contracts is that, you know, you own it. And it's important to say that clause should be in your contract. It's not long or anything. It's just, you know, it's just making sure that both parties know that all the works that you present are yours. Sometimes it's amazing how many clients, I think, sometimes think that because they hire you, because they've hired you and you're designing for them, that they own that, but they don't. And unless you come to an agreement otherwise, you know, that you have copyright protection. And that's why it should be spelled out, because a lot of people just think that, you know, when they hire someone, that anything that person creates is theirs. And I understand that. It's a common misconception, though. And it's, yeah, again, why the provision, right, is important to be in the contract. I see a raised hand. It's exciting. I wanted to mention that to you guys too. I love to be interrupted and to kind of answer questions in real time. So Beth, is there a way I can address a raised hand?
I think we'll save all the questions till the end, if that's okay.
Okay, yeah, that's fine. We can do it that way too. But one thing that I'm seeing more and more is that these IP assets are being treated as deliverables, as something that can be bought and sold. And that's what I mean by that, right? That your client might be buying your design from you because, I don't know, because they've hired you and you work for them. Trademarks can be bought and sold. It's true. But if you have a client who's interested in ownership of your design or licensing your design for any reason, you should be compensated for that. And I guess that's what I mean by this design being treated as a deliverable, as if it's just something, right, that's flowing to the client, when really what it means, and what they probably don't know, is that if you're going to do that, if you're selling designs, you are giving up your legal copyright to that design. You are transferring ownership. So it's a different kind of transaction than just, well, what would I'm just making this up, but like, what would a package of 5 drawings look like? Well, it's more than just that, right? It's more than, how much time did I spend on this? I'll charge by the hour for each drawing, and then that's how much this is worth. It's because there's a transfer of legal right. The American Institute of Architects, for example, recommends they just take the stance, you know, that in the industry, there's, like, you should never give away copyright, that there's no reason. The most they want to see people doing is to license those drawings, and there are ways to do that. One is exclusive, one is non-exclusive. If it's non-exclusive, that means that you can license that drawing to someone else, to another client. But if it's exclusive, and some of you might be in this position where you're working, you know, with someone who wants it to be exclusive because maybe they're an owner of a restaurant, you're designing, and then they want to apply a design and they want a uniform sort of brand across, you know, they hope to open other locations, right? They would want that to be exclusive because they don't want other restaurants to look like anyone else's. This is, you know, kind of just an example. So that's the difference between an exclusive and a non-exclusive license, just so you know. But, you know, kind of contractor treatment in commercial contracts, being more interested, I think, in design purchase without proper compensation are just, some of the ways that some of the trends that I'm seeing in terms of how maybe some other, third parties are kind of thinking about designers in contracts. So I don't mean this to be like a negative thing. It sounds like it, it sounds bad. Like, beware of this right treatment. Like, someone's undercutting you, someone's really not understanding your role, someone's going to try and, get something from you from nothing kind of thing. It's just, it's why I think attorney review of agreements and deals that you're thinking about getting into is so important because it just means that you can make some business decisions, and assess the risk and just try and make sure that if you are, maybe willing, right, to take on a little bit more responsibility in kind of a shared liability way in the project, that you're compensated for that. That means something like, base design fee goes up or something. One thing I didn't mention, is indemnity, which is a provision that can be in contracts, whether you're in the commercial space or whether you're working on residences. Typically, I think it's a little bit more common to see limitation of liability clauses in contracts where you're working on homes and offices for a person, for an individual, or for a family. But those contracts do have indemnity provisions too. Indemnity is a risk shifting concept that says that you're willing to take on the responsibility if your client, gets sued by a third party and they, someone got hurt on premises or something like that, and they think that, it may be the fault of the designer. So often, another thing that's happening is that these provisions are more and more drafted by the client. So that means they might be a little bit less favorable to you, a little bit less balanced. And I can give you an example. It's called a client-centric indemnity provision, and it looks like this. So the designer shall release, hold harmless, defend, and indemnify the client against all claims, damages, losses, costs, liabilities, judgments, and expenses, including attorney's fees and expenses, arising from, related to, or in any way connected with the designer's performance. So that's huge. Something like this just opens you up to a lot of liability because it says all claims. It means, anything. It says in any way related to or connected to your performance. So, right, that could be anything. A much more, I would change this if I were looking at it and you were like, hey, I got this contract and, what do you think of this? I would change this just to make it much more, not to kill the deal. I recognize that too. One thing I'm really sensitive to is the fact that, right, you want work, like you're trying to get contracts signed. It's not my job to strike everything and, send it back and say, figure it out. There are ways, though, in cases like this, in scenarios like this, to balance this language. And what you would want to do here with specific to indemnity is to tie your obligation to your negligence only. That narrows it down a lot. So you can see here, it says, related in any way to your performance. No, your liability only comes from, it being proved that you were actually negligent. And negligence is a standard. It's pretty hard to meet. I mean, you have to basically knowingly do something unsafe, right, in order to be guilty of that. So those kinds of things go into kind of what the climate is now a little bit, and some things, sort of pre-pandemic that were popping up. Again, though, not bad, just ways to think about, how to protect yourself and also just negotiate. If you've ever been approached for with an interest in someone owning your design, you saw that in a contract, or you thought that you wanted that to be part of you know, your new project, that's fine. It doesn't mean that you can't do that. You might not want to, in which case, you know, you're going to say, no, I own it, and that's the floor. If you do, though, then you can just negotiate fees around that, right? It's compensation. It's not meant to be just that you're on the disadvantaged end of that transaction. This is all just, you know, this is transactional after all. So here are some things I'm seeing that are a little bit newer that I wanted to talk to you about today too, in terms of kind of what's coming up in this industry. I see a lot more opportunity for designers for product design. I'm working on a lot more product design licensing agreements. So that's kind of why I wanted to bring that to your attention today. That a product design and licensing agreement, you know, I just want you to know, is a separate agreement, a separate kind of agreement that usually involves the fee structure, right, for product furniture design for in terms of payment is royalties, but that can also be combined with, you know, a flat fee. I really like the idea. If you are thinking about doing this, if you've done this, if you've been approached to do this, you know, recently, if this is something that, you know, sort of speaks to you in any of those ways. I've just seen a contract I worked on had, you know, right, some flat fees going for every design submitted to the manufacturer, but then also a nice, you know, royalty structure in place for sales. I admit, before I started working on these agreements, I kind of thought that product design was always big and huge, right? Big lines, big names in terms of, right, the companies, the manufacturers. This is not true. It can be just a very interesting thing to do if you're interested, you know, in it. And the scope really, really varies in range. So when I say royalties, you know, I don't mean huge necessarily, maybe, but not huge checks coming in every month. It might not be that way, but it doesn't have to be that way to be a part of your business, to be something, you know, that you do on the side, to be something that for many reasons you might be interested in bringing into your business. I've met a lot of designers who are really interested in that and who, you know, have designed something, you know, a piece or two that they really like, but maybe don't want to put out in front of the client because they don't want to seem like they're double dipping or double dealing, or, you know, to make it seem like they're only putting, right, their own product in front of the client in terms of when they give them options. But I've found that my clients often like to see what they have to offer. I had a client who had designed some things and didn't tell their client when they were working on a project with them, didn't present, right, this client with that option, but they shared on their social media feed what they had designed, and their client was like, why didn't you tell me about this? I really, really like this. I would really like to consider this. So that's just an example of how, you know, this might be an opportunity for you. Know, though, in terms of the legal piece, in terms of the contract side of it, that these documents, these product licensing and royalty agreements should be reviewed by an attorney. They can really vary. It is not a good idea to try and find a template for this. You're going to get boilerplate language that probably doesn't even speak to your deal. I've found that these deals have been very, you know, specific, really just across the board. Most projects, right? Everyone is kind of specific and unique, and there's no way that a template with some kind of prefabricated language in the contract is really going to be representative, and you might, you know, leave yourself really unprotected. For example, if a establishing that you have copyright in your design when it comes to a product design contract deal. It's really important to say that, right, to make sure that you're saying that you own the design. Otherwise, the manufacturer has license to just take that and not pay you and multiply it over and over again. And I've seen contracts be presented, without that protection in there. So partnerships, a lot more different kinds of collaborations coming down the pipeline. I think that people are really interested now, I mean, as they always are, but maybe just right now a little bit more so in recent years, of finding ways to, professionals within the same field, right, in industry, finding ways to hook up, link up, kind of collaborate, together and move forward with business in a different way. It might not be that people are looking at as many traditional models of hiring designers anymore in terms of who you work with. You might decide that independent contractors are, is the way that you want to go. Someone might be freelancing, right, their work in that way. They don't want to be a W-2 employee, so perhaps they, are willing to sign an independent contractor agreement depending on what they have going on. And right, so then it's just figuring out what kind of relationship you want to have. And I highly recommend putting that in agreement form as well. Anyone that you work with, really in any capacity in that way, making sure that you have, the right agreement. I think independent contractor agreements are really important. And one really important piece there is that you make sure that there's a certain amount of independence and decision-making left to that person who's doing the work for you. Otherwise, the IRS sees it as an employer-employee relationship, even though you didn't say it was, and even though you have an agreement saying this person is an independent contractor, you could actually be on the hook for being responsible for them in an employer capacity if what you really did was, controlled a lot of their time, dictated a lot of their tasks, controlled a lot of the equipment that they used for you, right? If they're working with all your equipment all the time, in your office space, certainly that's probably going to be viewed as more of an employer-employee relationship. And just in terms of ways of diversifying revenue streams, which, product design is one, but sweat equity, maybe, finding ways to maybe become parts of projects or deals that are a little bit outside of the time for services billing model. Sweat equity is getting paid in kind, not in money. So you might be interested in looking at yourself or your business being, having an ownership stake in something that you work on. Please consult an attorney. If you do, I've worked on these agreements. You're probably wondering, there's so much to say about it. And you're probably wondering, for one thing, how do you get paid then? It's really pinning down what the value is that you're bringing to the project. Can be tricky and really varies, but it's not impossible. And I've seen, there are several designers I know that have really wanted to enter into agreements with clients that are like this, rather than just forego the project altogether, because the person that they're partnering with or want to work with, maybe they don't have the cash right now to put up towards those design fees, but maybe there's another way, which is called sweat equity. That's the way in which the designer can be part, right, of the project, without walking away and just saying, well, you can't just pay my invoices right now, so I'm not going to do it. Really interesting, and exciting, new things to consider. And I wanted to kind of try and paint a little bit of that picture for you guys of this legal landscape that's, kind of emerging, obviously always there. I mean, none of these things are anything that have just been made up, right? But they are becoming more common. that is what I have seen, right, in my practice, which focuses specifically on this industry and on, you know, interior design, working with interior designers in this field. So this might be a really good slide before questions. I know I could talk about this stuff all day. I'm sure I've thrown a lot at you. I wanted to talk about, right, legal treatment, and like I said, kind of this new, these new emerging business trends, because in the end, this is all about facilitating, you know, business and growing your business too. In the best way, in new and exciting ways. I think a legal professional, you know, is absolutely part of leveling up and kind of bringing on your team to make sure that as you do these things, think about these things, go through and, you know, and keep working with people, keep doing projects, that you're also doing it in the right way, that you're protecting yourself. Yeah, and that you have agreements, you know, moving forward that really give you the best possible chance of having a project go really nice and smoothly because you've thought about your time a lot. You know, you and your client are in agreement about it, and that you're very clear about, you know, fees and everything. So separating additional services, as I said before, one of the biggest and best ways to protect your time. Crafting language around suspension and the hurry up and wait scenario. I know when I talk to my clients and listen to them, a lot talk about, you know, the fact that their clients will push and push and, you know, be pushy and want work and wait for things and then not get back to the designer. And it's like, in the meantime, that's your time and fees. So I'm really a fan of having language around termination and suspension in the contract. I mean, it's absolutely a must. It needs to be, but it tends to look a little bit longer maybe than everyone thinks, which I think is okay. It's just that the great thing is that those few clauses can really address, right, this scenario. You cannot legally enforce anyone to get back to you in a timely manner. It's not that that's the legally right, enforceable right, but by writing language like that, and I've done that, I've actually used that phrase, like, you know, client agrees to render decisions in a timely manner so as to, you know, facilitate the orderly and timeliness. And now I'm kind of making that up, but you understand, of the project. You can't enforce that. I think it's so nice to put out there though, just so that the client can kind of have an eye on, you know, what expectation is. And what you can do is when you talk about things like that, then you have some grounds to say, and if client is unresponsive, then I can assume project has been suspended. Now you're back to a suspension bucket and maybe you've worked out a fee, you know, that there's a suspension fee or a startup fee. Startup fees, I think, are very important, can be very important and effective for addressing the scenario in which, you know, things are put on hold and you've done some work and then you're asked to jump back in later, you know, where in the meantime you have started another project, or, you know, you have your time and energy and maybe a few employees' time and energy going somewhere else, and you can't drop that either because you've made a new commitment. So suspension and termination language, very important, maybe even a termination fee, depending on your situation. If you are comfortable who your client is, I just wanted to put that on this slide, right, as another option. Also, in that same way, extension fees through no fault of designer. You know, I understand that sometimes there are things beyond, right, everyone's control that just are going to make the project take longer. And you don't want to nickel and dime your client. I get that. And they're not going to pay you maybe just because the contractor messed up. They're just certain scenarios there though, where that might be appropriate. And I wanted to address that too in terms of project extension, because I know, you know, one thing that's going on now is like production and shipping delays. which isn't entirely new either, but maybe is in a different category now because of the pandemic. I would say that it's very important to have a limitation of liability clause. You might not have linked that before in your mind, but a limitation of liability just sort of nicely says, and those are in the contracts I write for my clients who are working on homes and things like that. It tends to look more like an indemnity clause in commercial contracts, but limitations of liability on projects of any size, just so that those kinds of things can't come back to you. When I say those kinds of things, I mean these shipping delays, right, and maybe production delays. These are also your exit strategy clauses. That's really important. And I think someone asked about that. I think someone may have submitted that question ahead of time. I love an exit strategy. I just think it's smart and really important. If this or that happens, scenario A, B, C, what would I do and how can I walk away without, losing everything? That's where proper termination and suspension language really helps you. You want to say, look, if the project's been on hold for this amount of time, I have the right, to walk away without any liability. If it's ended, terminates, then I have a right to collect fees on the last remaining invoice that I submitted to you, things like that. Beth, I think that is now a good time. Can we take some questions now? In our last few minutes, it goes so fast.
Yes, let's do that. So we have a lot of great questions here.
Awesome.
So the first one involves having an established contract with a client. So you have that in place and the scope of work, or a new agreement comes to place via email that you both agree to. Does an official addendum have to be done or a new contract drawn up, or does the email itself with agreement back and forth considered in a legal document?
That's a really good question. There's something called an implied contract, where even though you don't have an express contract that you have both signed, on the dotted line, a signature page that's attached to all the terms in a document that you've agreed to, there's something called an implied contract, where if if there's evidence like that, like emails where you've agreed to terms and you've both started, that someone might be right on the hook for paying you. It's tricky though, because it really depends. I would say overall, that's very messy, and I would really worry for a designer that in so many ways it'd be very likely that that would not constitute a legal binding agreement, and that someone could just walk away with fees. So certainly, I wouldn't do that on purpose, I guess, is what I'm saying.
Proceed with caution.
Yeah, proceed with caution. Exactly. If that's the deal. And I would be saying in an email, yes, please look to the attached, contract for my terms, and let me know if you have any questions. And then once you sign, we can move forward.
Great. So what about photos and legal rights do designers have to their photos and for other people to publish them or use them?
Great. I'm so glad someone asked, and that you're asking this question too. I meant to address this too. I'm sure this was somewhere in my presentation. So you have rights. If you are the photographer, you own your photos, period. Same thing with the client though. If the client takes photographs, they own those photos. So that's the legal right doctrine. Whoever takes their photographs owns those photographs. I like separating a publicity and photography provision in contracts, because publicity speaks to your rights to sort of use your photographs and write in your own advertising and promotional materials. Photography stipulates like who might be paying for a photographer, and then you can agree maybe there to, like, if you want to be a part of the shoot, like that you want to be provide creative direction, and you can ask for a CD for a file. But I will say, if someone else is taking the photographs, you don't have a legal right to them. That's just then that becomes about you and your client working out what kind of files you might be able to get from that and use on your own materials. But certainly anything that you document can be used in any way that you would like for yourself, and you own it.
Great. So question about sourcing here, which is something that we get a lot as well, of designers working with clients, showing off their presentation, and then the client going elsewhere to source that same good without the designer markup. Is that just something that you put in the contract from the very beginning, or how does the designer protect themselves from that?
In terms of, can you say the first part in terms of, did you say?
So a designer preparing a proposal for a client, and the client taking the products that were sourced and finding elsewhere to purchase them. Now, a lot of manufacturers do have online sources or access for consumers that maybe was blocked in previous years.
Right. That's tough. I think that, before I'm assuming that this is before, you've officially agreed to work together. There's been no money, right, paid for time or services yet. You're really just pitching. I would think maybe if this keeps happening, I would think maybe about what it is you're putting forward, how much right is there for someone to go take and then do a different way, because unfortunately there's really no way to protect it. At that point, you don't own, you own the drawing, unless you're giving things like that over, right? Which I wouldn't before anything has been signed. But if you do, then it's unfortunate. That person, I think, can really, doesn't have to retain you to continue with the project or to have you actually execute that.
Okay. So getting back to IP, if a commercial client pays you for design services, then recreates that design on future projects, do you have the right for the design to be replicated? Do they have the right, or is that all per contract as well?
That is all per contract. They do not have a right to replicate the design on another project. Yeah, you would have to, the designer gets to license that. You can give them the right, but they don't, and that should be in the contract.
Got it. Okay. Let's see what other questions we have here. Obviously you've worked with a wealth of clients that have different needs, but how often do you see clients kind of flexing what's in their contract to secure the job? And how often do they change from job to job?
I would say that the biggest breakdown I see is between commercial and residential. There's more similarities to contracts within the commercial space among each other. Same thing with residential. Those two can vary greatly, from each other, but within those areas, there are similarities. I would say I'm not really sure that about flexing anything like within a contract to actually secure the deal. I think it's the terms, right, that have kicked off that fact that a contract might be forthcoming. And then the contract is really just to make sure both parties, are in agreement going forward and that they agree to be bound. So, pitching, I think, is so great. That's why I really make a distinction, I think, between those kind of pitching promotional materials like proposals, requests for proposals, and then also, the services proposal that go out before the contract even comes along. Hope that answers that question.
Great.
For the most part.
And one last question before we go for the day. So a designer met with a custom home builder and kind of showed her portfolio of work, and they had asked to keep a few of those photos just as they're deciding what designer they're going to go with. Does that automatically protect, because her logo was on there, that designer from copyright law, or should she be concerned that her design may pop up in one of their future builds?
It's possible. I would say, it's unlikely, right? If your logo is on it, I don't think that there'd be that many bad actors that would do that. That certainly is, I think, really smart to make it clear. What I would do in that case is, if you're going to do that, right, have it go along with something. I mean, certainly have your logo on it, that it's your copyright. I think I would state that. So you are protected. And at the same time, the answer is yes, technically, if someone else has that right, they could always do that, even if they didn't have the right. And that reminds me, and going, I just want to say one quick thing to address the question about if there's any way to protect yourself when you're working with materials that you might show or give over to present to a client. Again, you don't have a contract, so it's tough, but I did want to say that when it comes to having the contract, there is a clause that's in there in terms of under this copyright section for designers that says, hey, if you do go use these designs without us, we are not liable. So I just wanted to say that so that, you know, designers know they can be in these scenarios where someone does these things, that they're not, they can protect themselves by saying, hey, if you're a bad actor and you go and you do this elsewhere and you don't retain us and we don't know about it, we are not liable. And that, you know, that would be though in an agreement. That's why it's so good to have one when you start working with someone.
Wonderful. Well, thank you, McKenna. I think we could go on and on. You have so much great insight information to share. We really appreciate your time today.
Thank you so much. Thanks for bearing with me.
Yeah, and if anyone wants to catch a copy of this presentation, the recording will be on our YouTube page in a couple days, so check back for that. And don't forget to mark your calendars for our next Business of Design on Wednesday, February 17th at 3 o'clock. Sarah Shuko from Sarah Jacqueline Interiors in Chicago will be chatting with Lisa Gilmore from Lisa Gilmore Design in St. Petersburg, Florida, to talk about from struggle to success and actionable steps you can take to grow your profit. So check out our website at designcenter.com or follow us on Instagram at DesignCenterMart. Thanks so much. See you next time.
Thank you.
Thanks, McKenna.